Good afternoon, everyone. I'll wait for the background noise to die down a bit, but some introductions from us first. My name is Kurt Hageman. I'm a partner in the antitrust team of Baker McKenzie, based in Brussels, and I'm extremely fortunate to be joined on this session by two star members of our team who are involved in the topic that we are going to talk about today on an everyday basis, fighting with the regulators that we just heard talk in the previous session. So Kirsty, Roma, please introduce yourselves.
Thank you very much, Kurt. So my name is Kirsty, and I'm an associate in the London Antitrust and Competition team. It's really nice to be here today, and I'm looking forward to hopefully catching up with some of you after the session.
Thanks, Kirsty. Yes, I'm Roma. I'm also an associate in the competition team. I initially trained in London, but I'm now part of Kurt's team in Brussels. I say recently, but I've been there for 2 years now. Time flies when you're having fun.
Exactly right. Exactly right. So with the introductions out of the way, let me just give you a quick overview of what we're going to focus on. I mean, the title sort of gave it away: global cartel enforcement trends. Cartels, you heard the authorities say in the previous session, it's the bread and butter, it's something that they always do, it's something that they are very much focused on and continue to focus on. So you may wonder, well, is there anything new to be said on this topic then, since it's always been there and it will always be there apparently? And what the answer is yes. We see some very important new trends that we're going to talk to you about this afternoon, or rather that Kirsty and Roma will be talking about, sharing their experience on the different topics. But where they will be coming from is, rather than just talk about the trends, is also talk about the risk that these new trends bring for companies, and how you can manage those risks, and how we also, as outside lawyers, work with the in-house counsel in trying to manage that risk. So we're going to keep today's session extremely practical, and hopefully also have a conversation around some of the things that you see, answer some of the questions hopefully that you may have on some of the trends that we're going to discuss. And broadly speaking, what are the topics we're going to cover today? Global cartel enforcement always begins with investigations, right? And the first topic to cover there is that we are in the middle of a huge spike in the number of investigations that we see around the globe. We see this in Europe, but not only in Europe. That's one thing, but the more interesting thing, in addition to the spike in the number of investigations, is also that we see significant differences in how the authorities conduct investigations. And Roma and Kirsty will be talking about the changes in how authorities do data searches nowadays, and the intense demands this puts on companies and on the teams on the company premises to collect what the authorities want to see at a pace and at a speed that the authorities deem normal and reasonable. And believe me, it's not always normal and reasonable in practice, as Roma and Kirsty will share with you. The other aspect there is that we see a very significant change in how authorities do raids, in that they're not only doing raids as company premises anymore, but that nowadays, as a matter of course, raids are also happening at employee homes. Many authorities have had that power always, but it's been used sparingly in the past. Those days are over. And for companies to try and help employees in those situations can be very difficult. And we'll be sharing some experience in how we do that, how we can help manage that, to give some ideas around how you can contain that risk as a business. So the number of raids that we see, how raids are done, is one topic to cover, but obviously we'll be speaking about the substance of cartel investigations as well, horizontal investigations. And what we see there is that the authorities are increasingly broadening their horizon in terms of what they consider to be problematic cartel behavior. Long gone are the days when all cartel investigations, or most cartel investigations, were focused on salespeople, when it was all about customer price fixing, customer allocation, bid rigging, etc. Competition authorities are increasingly aware that there are several other areas where companies compete with each other. We've heard sustainability this afternoon already. We're seeing guidance on this point, but we're also seeing a growing number of investigations. Talent, the war for talent, is another area where companies are constantly competing with each other. And we see a growing trend of cases that are on the horizon. And this in particular is an area where companies are very often insufficiently prepared. And there again, Kirsty and Roma will be sharing some tips on how you can begin to tackle that risk in your own organization, in the guidance that you give to your employees, because compliance training should certainly no longer be focused on sales teams alone. So with that out of the way, allow me to go to the substance of dawn raids and what we see there. And Kirsty, do you want to take us through not the small print on this slide, but at least the trends that this slide is supposed to show? Thank you.
Yeah, thanks very much, Kurt. I hope you can hear me okay, but let me know if not. So yeah, this slide here, I hope you can see some of the small print that Kurt mentioned, provides an overview of global DOM raids in 2023 and so far, what we've seen in 2024. And as we know, authorities were not able to raid during 2020 and to 2022. And following the pandemic, authorities did mention that they had a backlog of cases and that there would be more raids. And we're certainly now seeing this in practice. We're seeing an explosion in raids, like Kurt has just mentioned. And in terms of trends, what we see is there have been raids across the world in various sectors. Some of the industries featured here, for example, include the construction sector, pharma, automotive suppliers to fragrances. Essentially, no sector is safe from these raids. And there's also been a rise in multi-jurisdictional raids, with simultaneous raids happening on multiple jurisdictions on the same day. We know that agencies are cooperating with each other and sharing information. And we'll discuss shortly what is triggering the increase and the uptick in enforcement, and given this rise, what companies can do to prepare. Another trend we're seeing is the globalization of enforcement, which is clear. There's a lot happening around the world. For example, authorities in Turkey, Saudi Arabia, and Brazil are very active. And we're also seeing a new wave of cases in respect of supply chain related issues and economic pressures. We expect this increase in raids to continue. And so given that, I would like to hand over to Roma, who's going to discuss what the triggers for this increased enforcement are.
Thanks. So, as we've alluded to, it's definitely fair to say that cartel enforcement is no longer just a concern in the EU and the US, which would be the traditional hotspots. We're seeing a lot more increased enforcement in other jurisdictions. So, for example, in South America and also in Asia. Of course, there have been kind of sophisticated regimes in place already in parts of Asia like China and Hong Kong, but we're now also seeing a lot of enforcement in Southeast Asia. And Kirsty just mentioned there's two other jurisdictions that we thought were worth flagging. So in Turkey, the local authority has been very active. There's a lot more cooperation or coordination between the Turkish Competition Authority and the European authorities. And last year alone, the Turkish Competition Authority imposed fines of 2.7 billion lira in total. So definitely one to watch out for. And the second one, as Kirsty mentioned, is Saudi Arabia. So another one to watch out for. In 2022, they conducted 29 dawn raids. So what is bringing about this increase in enforcement? The first and most obvious one is leniency applications. So we know that leniency applications are on the rise again after COVID. The European Commission confirmed that in 2023 the number of leniency applications increased for the third year in a row. But we also know that competition authorities are trying very hard to move away from relying on leniency applications solely. So a European Commission official said in Florence, I think at a conference this year, that they were trying to focus a lot more on ex officio investigations and move away from their reliance on leniency applications, because the Commission have noticed a trend that companies are adopting a kind of wait and see approach where they'll prepare a leniency application but they won't submit it because they're waiting to see whether or not an investigation might be started. So the Commission are really trying to get away from that, and they're investing a lot in ex officio investigations and trying to identify their own kind of cartels or their own breaches. Also as well, this is not just in the EU, but we've seen in the UK, for example, the CMA have invested quite a lot in their whistleblower programme, and they've recently increased the financial incentive from 100,000 to 250,000. So quite a lot for a disgruntled employee. And then, of course, we've also seen that there's quite a lot of coordination between the agencies globally. So whatever information the DOJ are learning, they're going to share with the European agencies and the UK agencies. We've seen also coordination with Switzerland, for example, and Turkey recently. So yeah, there's a lot more linked up kind of coordination and information exchange between the authorities as well.
Thanks very much, Roma. So now we just want to take a few minutes to talk about the key challenges that companies can face when it comes to dawn raids. So first of all, where are dawn raids taking place? Well, as we mentioned already, dawn raids are taking place in multiple jurisdictions, but we're also seeing them taking place in multiple locations at once as well. So not only at company offices, but also at employees' homes. And this can add to the complexity of the raids, and companies should be prepared to handle the raids happening in these multiple locations simultaneously. And this can add a lot of pressure and stress that the employees involved are under, particularly if raids are happening at an employee's home. And companies should ensure that employees are aware of this possibility. And how can companies prepare for these raids? Well, one thing that they can do is companies can carry out walk-through raids, which enables a company to stress test the policies that they have in place. But we would also say that companies should ensure that their dawn raid policies are up to date, particularly following COVID, and the policies may now be outdated, and so should be reviewed and revised to ensure they're still fit for purpose. And it's really crucial for companies to have guidance in place and to make employees aware that there's a system in place to help them when they're raided, because it's a very stressful time for any of the employees involved in the raid. And we as a company have a dawn raid app that companies can use, and we've developed this so that we can provide immediate support to companies who are involved in raids. We can be on the phone immediately, and we can talk with the authorities who are there, and we can stay on the line until someone arrives on the premises. So this can hopefully help put some of the stress or the employees at ease. And in respect to policies, having an up-to-date policy that addresses what to do in the event of a home raid can also be really crucial for the employees in that situation. So setting out what steps they should take can help reduce the stress and avoid time delays, and also avoid the risk of obstructing the authorities. Well, Roma, I think this is now actually you. You're going to chat about the risks. Yeah, thank you.
Thanks, Kirsty. Yeah. So another key challenge that we're seeing recently, which is probably not a surprising one at all, is that dawn raids are becoming more and more electronic data focused rather than authorities trying to collect hard copy documents as they might have been in the past. So with this increased focus on electronic data also brings an increased risk of destruction of electronic data. So I think the kind of classic image that you would have of data destruction in a dawn raid would be someone upstairs shredding paper while an authority's kind of doing a sweep downstairs. But these days it's actually people deleting WhatsApp messages, and I'll cover that a lot more in the next slide. But yeah, with this increased focus on data, it means that the requests that are coming from the authorities are becoming more and more complex. So they're asking for data that is hosted across multiple different platforms, and might be located in different servers in different jurisdictions. And it's really important that the local IT team that are at the premises for the raid are able to answer these questions from the authority, and are also actually able to access and provide the data that the authority is requesting. Now, whenever we attend on raids, we bring our own e-discovery team to basically help bring this along, because it's a whole field in and of itself now. But yeah, I say make sure your local IT team are able to answer these questions. It's super important that, say, if you're a company that's located in different jurisdictions and in different time zones, if you're being raided and you're relying on an IT personnel who's in another time zone, that's going to cause a lot of delays, obviously, for the dawn raid. But it could also it doesn't get you off on the right note with the inspection team, and you obviously want to have good rapport with the team that are doing the dawn raid, and also potentially going to be working with you on an investigation for a number of years. And also, as Kirsty mentioned, there's more coordinated raids that we're seeing. So the UK, US, EU, and then also some other countries as well. So we've seen Turkey and Switzerland. So if you have if you have one IT personnel or even one IT team that are having to basically respond to all of the requests from potentially 4 different authorities, that's again going to cause a lot of stress and a lot of potentially time delays. So yeah, just make sure that your local IT team are aware and they're up to speed with what the authority might be asking. And I mentioned our e-discovery team, our in-house e-discovery team. They can work with your IT teams as part of your dawn raid prep to get them ready for the types of questions that a regulator might ask. And I'll hand over now.
Thanks, Roma. And one other important consideration when it comes to dawn raids is data protection considerations. And in respect to this, while it's important, obviously, that authorities are able to access the data, it's equally important for the company to be able to access the same data to conduct its own investigation. For example, to help with leniency applications or the preparation of a defence. And for the company's own internal review, companies will need to demonstrate that its own data collection, processing and review has a legitimate basis, and that it has introduced adequate safeguards to mitigate the risks of data privacy issues. And for example, issues that may be encountered could be where companies don't have an appropriate policy for the use of mobile phones for business purposes, and have to introduce such policies before they can image and review the data on these mobile phones. And this can slow a company down and could have an impact on a leniency application, for example. And another thing to consider is where the data is located. For example, if it's in another country such as Switzerland, steps may need to be taken with regard to, for example, a Swiss blocking statute, and you may need to reach out to Swiss authorities in that regard, which could add time onto your investigation. Therefore, it's important for companies to ensure their internal data protection policies are always up to date, so they can take action immediately if a raid does take place.
Thank you. So this slide is basically just an overview of some recent fines in the EU for obstruction. So it might be a kind of self-evident question of why you should cooperate with an authority, but in case you weren't sure, here's why, basically. And the headline fine is one that is quite recent. You might already be aware of it, but in June of this year, the European Commission fined, I think it's International Flavours and Fragrances, 15.9 million for a senior employee deleting one WhatsApp message during a dawn raid. the European Commission can issue a fine of up to 1% of a company's worldwide revenues for obstruction. So the kind of really shocking thing about this fine is that it actually could have been closer to 32 million. The company received a 50% discount for cooperating with the authority once the deletion was discovered. So you see, this is the first fine that the Commission has issued for deletion of electronic data, but we definitely don't think it's going to be the last. And we're also seeing that this is now becoming a concern outside of Europe as well. So the US antitrust authorities earlier this year said that the duty to protect data, or preserve data, extends to encrypted messages, and if anything goes wrong, that could lead to criminal liability for the employees, but also their legal counsel. And in the UK, we're expecting legislation later this year, which says that it's going to introduce a duty to preserve evidence if an antitrust investigation is likely. So obviously, this means that in the event of a raid, it's really crucial to get data hold in place and get document retention policies and instructions out to employees as soon as possible. We're seeing that the use of mobile phones, and WhatsApp in particular, is becoming more and more common for business purposes, and that means it's going to be, of course, more and more of a focus by the authorities. So it's really important, as Kirsty mentioned, to make sure that companies have adequate policy dealing with employees' use of mobile phones. And you can see on the screen, well, maybe you can't see on the screen, but on the screen there are also other fines. There are fines for other methods of obstruction as well. So one that came up a good bit was refusing access to certain data. There's very few grounds that you would be able to prevent an authority from reviewing data, and it's unlikely that you would be able to prevent an authority from imaging or searching that data source at least. For example, if data is located in another jurisdiction, you won't be able to use that to provide access to that data. The general rule of thumb is that if the custodian that the authority is interested in can access that data on their laptop, so for example, if it's in their inbox or if they can access it on a SharePoint site or a Teams site, the rule of thumb is that the authority should also be granted access to that. The same goes for personal devices. So even if a mobile phone or a laptop is primarily a personal device, if that person uses it at all for work purposes, then the authority will want access to it and should be granted access to it. Of course, pretty much every authority will have their own way of protecting personal data and ensuring that that's not, caught as part of the investigation. Generally they'll use like search terms to make sure they're only capturing data that's actually relevant to the investigation, and any data that's not relevant will eventually be deleted. But basically during the dawn raid, you can't use that as an excuse to not provide data. And another, like some of the other fines that you see on the slide, there's a couple for breaking a seal during a dawn raid, for example. A lot of these are just caused probably through negligence rather than actual intent to obstruct the investigation. So it's just super important for companies to be aware of these risks and prepared in advance, because if they know what the potential risks are, they can hopefully plan ahead and avoid things actually going wrong during the dawn raid itself.
Yeah, so that basically concludes the first topic that we wanted to cover today, which is the risk that the new style of investigations brings. The key topics to remember here really are the risk of raids at home and the risk associated with mobile phones. Because in our experience, most companies know how to deal with a government investigation when it happens on the company premises. There's a lot of support there. This is not a one-man, one-person job. There's a structure, there's support available, so the risk there is much more manageable. But when you have the police at your front door, when you have an inspection team in your living room, that's a different matter. When it's you on your own, with your partner, with your kids, sometimes, becomes intensely personal. When that inspection team asks for your mobile phone, people's lives are on their mobile phones. That's where we keep everything. So people see this as intensely personal, even if they use that phone mainly or also for business purposes. And we've heard the Italian authorities speak about temptation. That is where the temptation to hide something, to delete something, very often something that is intensely personal, that has nothing to do with the business, but they do not want to see that someone sees that photo, that someone sees that private WhatsApp exchange, and they delete it. And that is the sin that we heard about earlier when the Italian authority was speaking about temptation and sin. And unfortunately, we heard about this is a Catholic country, and in Catholic religion there is such a thing as forgiveness, but for this type of violation, antitrust authorities are unforgiving. So that is the key thing, and I see a lot of nodding from the front row. That is the key thing to remember here. And as a company trying to make your employees aware of this risk, explaining to them what will happen when an investigation takes place, explaining to them, yes, you will have to give your phone, but no, they will not look at your pictures. No, they will not search your private messages. They use very sophisticated search terms because they come very prepared. They know what they're looking for. They're looking at a mountain of data. They want to sift through that data. They're not interested in your private exchanges, so they will not look at that. Making them aware of that reality helps to at least reduce that risk that in the spur of the moment, they will do something that can cause a lot of trouble for them, but also for the company. So it's best practice to make them prepared for that. So that is, I think, the first message that we wanted to give today. Now moving to the substance, we've heard about sustainability quite a bit already today, but what does that mean, Kirsty, for companies in real life? And also from a risk perspective, how do you manage that? Thank you.
Thanks, Kurt. Yeah, so hopefully this plays ball. So yeah, we're going to move on to now what the enforcement trends that we're seeing, and sustainability is certainly one of those. And companies are often under pressure to demonstrate progress towards sustainability goals. And this is coming from stakeholder expectation, emerging regulation, and also just a desire for companies to want to be part of that solution. And this is an area which is high on the radar of antitrust authorities. And what makes this area challenging is the difference in approach taken by the authorities. In some jurisdictions, legitimate collaborations are given more flexibility, such as in the EU, the UK, Japan, and New Zealand. And in some jurisdictions, there are also guidelines to help assess collaboration on a case-by-case basis. And companies are being encouraged, for example, to consult with authorities, and the EU NCAs have been very active in this space. And some of the guidance that we've seen by antitrust authorities include, for example, in 2023, the European Commission issued updated horizontal guidelines, which includes a new chapter covering sustainability agreements, and which clarifies that the antitrust rules shouldn't stand in the way of agreements between competitors which pursue a sustainability objective, and reminds companies that they can request informal discussions with the Commission and guidance to ensure that they still comply with the EU competition rules. And similarly, in the UK, the Competition and Markets Authority has included an open door policy in its green agreements guidance for companies who wish to enter into environmental sustainability agreements. And further, in March of 2023, guidance was issued by the Japan Fair Trade Commission, and this guidance includes a section on business alliances. However, we note that the US authorities have said that sustainability collaboration will be treated like any other horizontal collaboration. So therefore, companies need to think very carefully if they operate across jurisdictions in order to comply with the different regulations and guidance, and not just adopt a one-size-fits-all approach to complying with sustainability regulations. Thanks, Kurt. And this slide highlights a number of cases that we've seen in the ESG space. For For example, one of the recent cases was of food companies in France, which involved collusion not to disclose information to consumers about the presence of a chemical in food packaging. So what we just wanted to highlight with this slide is that despite the guidance provided by some authorities on collaborating with competitors with respect to sustainability objectives, companies should make sure that these conversations don't stray into dangerous territory and that sustainability shouldn't be used as a masquerade for what is ultimately cartel conduct. And with that, I'm going to hand over to Roma to discuss HR issues.
Thanks. We know there was a session on the labour markets earlier today, but we can't mention global cartel trends and not mention the HR and labour markets. I think it's fair to say that it's definitely a new frontier in antitrust. Authorities around the world are trying to protect worker mobility after COVID-19 and protect wages, especially in the cost of living crisis. So, sorry, I don't know if this is my mic or... Yeah, I think it started in the US, but we're now seeing that this is definitely a global trend around the world. So we've seen cases, or we've seen investigations in Canada, we've seen them in South America, so I think Colombia, Mexico, and Brazil. We've seen a couple of investigations in Asia, so in Japan and China. We've also seen investigations started in the UK, Switzerland, Turkey, and then also, of course, the EU, so both at the Commission level and in a number of member states. I think last I checked it was 8 member states had opened investigations. So it's definitely fair to say that it's on the radar of every authority in all jurisdictions. And as well, in our experience and from what we've seen in the investigation so far, it's in a range of sectors. So it's, you know, you can't just say that it's, you know, a focus in the pharma sector. It's really across all industries. So what is the high-risk conduct that these authorities are interested in? The first is no-poach or non-solicitation agreements. So this is essentially agreements between competitors not to hire each other's employees or else to seek permission before doing so. One key thing to be aware of whenever it comes to the labour markets and HR is that it's not your traditional competitors that you need to be worried about. Of course, you do need to be worried about them as well, but it's much broader than what companies might think. So obviously a good example is lawyers. Typically law firms and their clients wouldn't necessarily be competitors in a traditional sense, but in a lot of instances they might compete to hire from the same talent pool, so that would make them competitors for this type of conduct that the authorities are interested in. So this means that it could be a company's suppliers or their distributors could actually be competitors in this context. The second kind of high-risk behaviour that authorities are looking into is wage-fixing agreements. So this is slightly more rare, but would be akin to like a price-fixing cartel, where basically companies are agreeing to fix or set salaries at a certain price, a certain rate, but it can also extend beyond salaries to basically any employee benefit. And then, of course, you also have just your classic information exchange cartels, where companies are sharing information on, you know, salaries, rates, or any other employment benefit. So essentially benchmarking off one another. And as with all information exchanges, this includes, you know, just your one-off exchange or like an unsolicited exchange. So if we go to the next slide, Kurt, thank you. How to stay ahead and manage these risks. It's super important for companies to train their HR team first and foremost and make sure that they're aware of these risks. But from what we've seen a lot of the time, it's not actually HR individuals that are engaging in this conduct. So it's also super important to expand this to all employees in the business that are responsible for making hiring decisions or that are responsible for deciding salaries or other employee benefits. Also super important to review any like supplier or distributor contracts to make sure that there's no non-solicitation clauses in there. It's also important for companies to make sure that they have guidelines for how to conduct a legitimate benchmarking exercise. The kind of safest way to do so is using a third party that's going to provide anonymized kind of aggregated data. And then it's also important to have guidelines for interviews. So of course it's fine for an individual to maybe disclose what they're being paid at a competitor in the context of a kind of salary negotiation, but companies need to be really careful that they're not just using interviews as a way to kind of gather intel on their competitors. And finally, be aware of industry events where these kind of discussions can take place. Of course, we all know that like industry bodies and trade association events can be beneficial, but they also carry so many risks from a competition law perspective. So make sure that if anyone is attending an event like this where information can be shared, they're aware of the risks and they know what to do and how to handle it, basically. So I will pause there.
Thank you, Roma. So to bring together these last 2 points, first on sustainability, I think the competition authorities, certainly in Europe and also in Asia, have been very open about the fact that they're prepared to help, that they're prepared to give guidance. They encourage companies to come in at the start of projects to help them guide through possible antitrust pitfalls. But that is the start. What we see is that it is very important to keep an eye on these projects, to keep an eye on particular types of cooperation throughout the life of the project, because we all too often see that something that was set up with all the best intentions, that started off as something beautiful, ends up being a bit of a monster. So you do see that other people get involved, the scope of the project changes, and things go off the rails. So compliance and compliance monitoring and making sure that your project stays on the right side of the antitrust rules is something that can't only be limited to the start. You know, when you set it up, it needs to be monitored throughout the life of the project as well. And that's one key point. For HR, this is probably a storm is coming there. We know from personal experience that the EU is looking at least at 2 live cases that they have picked. They pick these cases for a reason. They want to send a signal. And that signal tends to be a press release with heavy fines. That will come in a year or 2. And then everybody will be in a mad scramble looking at how their HR departments are functioning and who they're talking to. Our experience is that HR teams speak to each other all the time. There are HR circles in every country that I'm aware of, and they meet each other very often. They speak to each other about many things. It's time to involve them in your compliance training before the EU comes out with the next wave of decisions on this topic, because then it will be too late. So with that, I wanted to thank you for your attention and happy to take any questions now or later. And all questions go to Roma and Kirsty, not to me.
Quick question. So, is the expectation when it comes to rates at homes that to expect always a court order authorizing? Is that, or have you ever heard of a case where they go to the home and then, oh yeah, you need a court order? Yeah, sure. Let me get one. But of course, that can be an obstruction.
The procedural rules of each authority are extremely clear on this, and the authorities, in my experience, that's not an area where they play fast and loose with the game, because if they would violate procedural rules on this, that would undermine the validity of their whole inspection of the data that they've taken somewhere. So, and typically at EU level, and at least most of the member states that I'm aware of, when you're talking about a raid at a private home, they need to go to a judge first. And as we have seen, for example, in the UK, judges really want to understand why you think, as an authority, you need to go to that specific employee's home and why you think you can find information there and nowhere else. So the authorities are challenged on this, and challenged quite heavily. So from that perspective, I think we have the right protections built in, the procedural protections built in the laws of most of the member states that I'm aware of. But just maybe if from the authorities' perspective, there's something you would like to say on this.
Hello, Mirta Capo, Croatian Competition Agency. Not only that we have to have a court order, there have to be also two adult witnesses always present in the search of homes, but I have to tell you, we don't do it yet. We have not. So this is an interesting information for me that there is a rise in private homes down there. It's because we don't have this type of experience. We just go to the premises of the company so far.
I have a question on no poach. So I know that the European Commission's take is that they are trying to find a by object case, but they also publish a note on that or paper. But have you seen by effects cases in any of the jurisdiction that you mentioned in your slide?
No. I think it's not the time for the by-effects cases yet. We've seen cases where HR-related infringements were included in other plain vanilla type of violations, so more other types of purchasing, yeah? Because that is basically what it is, right? I mean, it's a purchasing cartel type behavior, where other types of behavior were included. But what I see, at least in the cases at EU level that are coming through, is that they're aiming for by object cases, so clear violations where they can, and they take these cases to send a clear signal. This is what you can and cannot do. You know. Effects cases may follow at a later stage, I don't know, but as we all know, I mean, they're less attractive for the authorities because they're a lot more work. You know.
Hello. I have two questions. One of them is about down rates, another one about the HR violations. So first, WhatsApp introduced a new feature which is called disappearing message. And a lot of companies in Turkey applying this policy for their employees. So what if automatically deletion happens during a down rate or shortly after the down rate began? That was my first question. The second one was, we know that now the communications between HR professionals or executives, between HR professionals and executives are risky now about the fees, about the other things, about the poaching and other stuff. But what about the communications, casual communications who are not executives or HR professionals, just, for example, two sales experts talking each other about their fees, not the whole company. Thank you.
Do you want to take the first question? Or?
Yeah, we have seen disappear messages come up in internal investigations. We haven't seen any in a dawn raid context yet, but I would imagine that if a company, so were you saying that was a company policy to use the disappear messages? Well, I would say if they're being investigated by an authority, they're under the obligation to prevent those, to keep those messages or prevent them from being deleted. So if a company is using those and is being investigated, I would say the company policy would have to be to turn that feature off and preserve all the data as much as possible. So yeah, in that case, I would say the company would need to kind of update their use of mobile phones for business policy to say that in the event of an investigation that they would have to turn that feature off and make any effort that they can to kind of preserve the data as much as possible.
Yeah, and imagine the risk that brings them in practice. How do you tell the relevant employees, as soon as you find out about a raid, switch that off now? Yeah. And imagine if because this is an automated function, something was deleted while the raid was already ongoing. So it is a real risk, yeah, definitely. Yeah.
Sorry. It's not really about disappearing messages, but sometimes I think people, when it comes to deletion of messages, if they delete something in a panic, they think that's it gone. But what we also see is authorities wanting to collect iCloud backups. So while you might think the message is gone, it might actually have already been backed up to your phone's iCloud backup. So they can retrieve messages that way as well. I'm not sure if that, I'm sure that must not capture those disappearing messages, but I think people sometimes forget about backups when it comes to deletion of data.
And your second question? So people talking to each other about their pay that they're getting and to see what, okay. Right. Yeah. To negotiate with their boss, yeah. Yeah. That's good negotiation tactics rather than an antitrust infringement is what I would say, but yes. Yeah. Unless you have different views on that, yeah.
Hello, I'm also from Turkey. Thank you for your inputs. I would like to ask something about on-site inspections. So you said that while doing the on-site inspection and while we're looking at their WhatsApps, they're not looking actually their personal messages. But in Turkey, we have a guideline about on-site inspections, and in there is a term which is a bit ambiguous, and it says that if the authority workers are suspicious about the messages between the employees. For example, if they say that it's just my friend, it's just my husband, but actually if they are suspicious, they can just quickly check it, look at it, and then if they see it, they can say, take it. So, I mean, I wanted to ask whether this is also the practice.
Personal messages. Yeah? They won't specifically go through the chats that you have with your partner, with whoever. What they do is they image the whole phone. So everything that is on there, the pictures, the private messages, everything. But given how targeted the searches are and how specific the search terms are, the chances, well, first of all, photos will never come up. Second, the chances that they will pick up a purely private message with the search terms that they use, in my experience at least, is extremely limited. And if it does come up, it will be filtered out immediately. Because what is private and what is not in practice is very, very clear and very obvious. And I have never known an authority to say, I want to look in more detail at something that is clearly just private.
Actually, in that regard, I've suffered a pretty good example, which is employees discussing about stuff that is relevant, but also exchanging emojis, sometimes political memes, which, I mean, at the end of the day, we're all human beings, right? And it's, if that makes into the file, it's embarrassing for the company. So yeah, private up to a point, I would say, and sometimes it can get a little bit mixed, right? The second thing I would say, that actually came up, your question on the out to deleting messages. My point would be, why would you want to delete evidence that is exculpatory, right? So he makes the question also even worse. How do you prove that actually was the conduct, the policy of the company, or let's say the conduct of the employee before the raid, right? I mean, I see a big issue of it's not what it looks like type of scenario, right? I just wanted to, I missed something in your presentation, and I don't know how many legal counsels, in-house legal counsels are in the room. Most. of us? No? 3, 4? All right, well, how about legal privilege? How about legal privilege? Any change? I mean, the landscapes are changing, right? It seems the laws are changing, but I don't know about the authorities. You gave us homework to do. We need to inform our clients and everything, but how are we supposed to do that if we don't have legal privilege for our comms?
There's a reason why we were silent on this, and that is that there is no change, at least not in Europe. Yeah? And to be honest, I don't see any change coming because the European Court has had the opportunity now 3 times to look at this, including very recently, and they have only reconfirmed what they've said for decades. You know? So in Europe, unfortunately, no. Member state level, there are exceptions, but when I listen to some of the antitrust authorities that do have these laws in place, they're not necessarily very happy about this because they feel that they don't have the same powers as some of their colleagues where these exceptions don't apply. So yeah. It's an uphill battle, and it continues to be. Yeah. But I am with you that the position of the court on this does not make any sense. But Roma, since we are in Rome, Roma locuta, causa finita, as they say. So yeah.